Imagine this. You have been saving for months. You booked your flights. You paid for your hotel. You went through the entire visa process, submitted all your documents, waited weeks, and finally got that approval email. Your visa is valid. It says approved right there on the screen. You show it to the airline at check-in, and they look at you and say, "Sorry, you cannot board this flight. You are not allowed to travel to Australia. Your visa is not canceled. It still exists, but you cannot use it. You are not getting on that plane, and there is nothing you can do about it. No appeal, no emergency call to a tribunal, no last-minute legal rescue. Just a door that was open yesterday slammed shut overnight." This is not a hypothetical situation. This is exactly what happened to thousands of people on the 26th of March 2026. Real people, real approved visas, real flights they could not board. And the mechanism that made it all possible is called Section 84B of Australia's Migration Act. And if you have anything to do with Australia, if you are planning to visit, if you are studying, if you are on a temporary work visa, or if you have family members trying to come, this video is one of the most important things you will watch this year. Stay with me, because in the next few minutes I am going to break down exactly what happened, how this law works, why Australia is calling it a pause and not a ban, why that distinction matters more than you think, who is affected right now, which other nationalities could be next, and what you need to do to protect yourself and your plans. This is not just an Iran story. This is a story about every person on a temporary visa anywhere in the world who is connected to Australia in any way. Let us start from the very beginning, because to understand what happened on March 26th, you need to understand what happened in the weeks before it. For years, Australia's Migration Act had gaps, big gaps. When a global crisis hit, a conflict, a war, a sudden surge of instability in a foreign country, the government had two main tools. It could cancel individual visas one by one, which takes enormous time and resources, or it could wait and deal with the consequences at the border after people had already arrived. Neither option was clean, neither option was fast, and in a world that was rapidly becoming more unpredictable, the government decided it needed something new. Enter the Migration Amendment Act 2026, also known as the 2026 Measures No. 1 Act. This piece of legislation was introduced into the House of Representatives on the 10th of March 2026. That is the same day Australia announced it was deploying its defense forces into the Middle East conflict zone. Think about that timing for a second. The military deployment and this new migration law were announced on the very same day. The bill was transmitted to the Senate on the 11th of March. A motion to send it to a committee for proper scrutiny was defeated. The crossbench received the full text of the bill at 11 in the morning on Tuesday and were forced to vote on Thursday. 2 days. A law that fundamentally changes how Australia controls its borders, passed in 2 days, with bipartisan support from both Labor and the Coalition. The bill cleared both houses on the 12th of March, received royal assent on the 13th, and came into force on the 14th of March 2026. And buried inside that new legislation, inserted into the Migration Act 1958, was Section 84B. So what exactly is Section 84B? Let me explain this in plain language because the legal text is dense and confusing, and the way the media has been reporting it does not always capture the full picture. Section 84B creates what is officially called an Arrival Control Determination, or an ACD. Here is the core of it. Under Section 84B, the Minister for Home Affairs has the power to issue a legislative instrument, essentially a signed government order, that temporarily suspends the travel rights of an entire class of offshore temporary visa holders. Not one person, not a few hundred, an entire class. That could mean every person holding a particular visa subclass, or every person holding any temporary visa linked to a particular country's passport, or both, at the same time. This is a personal power of the minister. It cannot be delegated to anyone else. Only the Minister for Home Affairs can sign this determination. And crucially, it does not cancel visas. That is the key point that the government has been repeating over and over. Your visa is not canceled. It still exists in the system. But while a determination is in force, that visa simply ceases to be usable for travel to Australia. The visa is technically alive, but it has no legs. It cannot carry you to Australian soil. And here is the part that has immigration lawyers genuinely alarmed. There is no individual notice required. The government does not have to write to you personally and tell you that your travel rights have been suspended. There is no merits review, meaning you cannot go to the Administrative Review Tribunal and argue your case on the facts. There is no natural justice provision. Section 57 of the Migration Act, which normally requires decision-makers to consider information that could affect an applicant, explicitly does not apply. The only court that can hear a challenge is the High Court of Australia, and even then, the constitutional limitations on judicial review make a successful challenge extremely difficult. In plain terms, this means a single minister can suspend the travel rights of thousands of people overnight with one signature, and those thousands of people have almost no legal avenue to fight it. Now, how does this work at the airport? Let us talk about what actually happens when an arrival control determination is in force. Airlines receive notice through the Advanced Passenger Processing System. This is the digital system that airlines use to check passengers against government databases before they even board. When a determination is active, that system flags affected passengers automatically. The airline receives an instruction that says, in effect, do not let this person check in. If a carrier ignores the order and boards a passenger who is caught by the determination, the airline faces what are called carrier sanctions, heavy financial penalties. Airlines were given just 24 hours notice when the first determination took effect on March 26th. Carriers operating out of the Gulf and across Asia had to scramble overnight to update their booking systems, their Dokyo messages, their thematic advisories, all the back-end systems that tell airline staff at the gate who can and cannot board. Some carriers had to rebook passengers and waive change fees on extremely short notice. It was chaotic, and yet it was entirely legal under the new framework. So who did this first determination actually target? On the evening of the 25th of March 2026, Minister for Home Affairs Tony Burke signed the first ever arrival control determination under the new Section 84B powers. The determination took effect from the 26th of March 2026 and is in force for 6 months, meaning it runs until at least September 2026. The determination targets Iranian nationals who are currently outside Australia and hold a visitor subclass 600 visa linked to an Iranian passport. According to figures given by Department of Home Affairs officials at a Senate estimates hearing, approximately 7,200 Iranians currently hold temporary Australian visas. Of those, around 6,800 are tourist visa holders who are outside Australia. All of those approximately 6,800 people had their ability to board flights to Australia suspended overnight, effective immediately. Think about what those 6,800 people represent for a moment. These are not people who did anything wrong. Many of them had spent thousands of dollars on flights, hotels, and travel arrangements. Some were planning family visits to see children, siblings, or parents. Some were attending business meetings. Some were enrolled in short courses at Australian universities. And remember, Australian universities recruited a record 200 short course students from Iran just last year alone. These are people who went through the proper legal process, paid the visa fees, waited for approval, and received it. They did everything right. And then, in one evening, the government signed a piece of paper and their approved visas became unusable. Minister Burke justified the determination in a press conference saying, and I am paraphrasing here because these are not exact quotes, that there are visitor visas which were issued before the conflict in Iran that may not have been issued today, and that decisions about permanent stays in Australia should be deliberate government decisions, not a random consequence of who had booked a holiday. He stated that the Australian government is closely monitoring global developments and will adjust settings to ensure the migration system remains orderly, fair, and sustainable. The core argument from the government is this: with the conflict in Iran escalating and civil unrest deepening, there is a serious risk that Iranian tourists who travel to Australia right now may be unable or unwilling to return home when their visas expire. The government is worried about what it calls return risk, the risk that temporary visa holders become de facto long-term residents because conditions in their home country make return impossible or dangerous. Rather than deal with thousands of individual overstay cases and potential protection visa applications down the track, the government wants to pause arrivals now and assess the situation properly. It sounds logical when you frame it that way, but critics are not buying it. And the criticism has been loud. Green senators and crossbench MPs have called this a massive betrayal of people who trusted Australia's visa system. The Asylum Seeker Resource Centre warned that this measure effectively prevents people fleeing danger from entering Australia, even when they hold valid visas. Human Rights Watch labeled the legislation cynical and cruel when it was first passed in March. Independent MP Zali Steggall flagged potential amendments that would at least require ministerial decisions under Section 84B to be tabled in Parliament within 48 hours. Refugee advocates argue that if someone is living in a conflict zone, the fact that they cannot easily return home is not a reason to bar them from coming to Australia. It might actually be a reason to let them in on humanitarian grounds. The legal community has its own set of deep concerns. Immigration lawyers from across the country have pointed out that the law as written contains almost no safeguards for individual visa holders. There is no requirement for the minister to consider individual circumstances before signing a determination. There is no appeal mechanism short of the High Court. There is no sunset clause requiring parliamentary approval to extend a determination beyond its initial period. The minister can simply issue a fresh order when the first one expires. And the law allows the minister to target not just one nationality, but multiple nationalities or multiple visa subclasses simultaneously. This is the part of the story that most people in the media have missed. Right now, only Iranian subclass 600 holders are affected. But the law was not written for Iran. It was written for any international crisis that Australia's government determines poses a migration risk. And during the Senate committee hearings, departmental officials did not just mention Iran. They provided figures for temporary visa holders from a wider range of Middle Eastern countries who are currently offshore and could be caught by a future determination. The figures mentioned in parliamentary records included countries across the broader Middle East region, and Minister Burke himself did not rule out applying similar measures to other nationalities. He was explicit about it. He said the government will adjust settings as required. That phrase, adjust settings, is bureaucratic language for, we might do this again. So let us talk about who could be next. And I want to be very clear. Nothing has been announced beyond the current Iran determination. But the framework is in place, the precedent has been set, and the trigger conditions are broad. Under Section 84B, the minister must be satisfied that an event outside Australia has occurred that creates an increased risk of overstay, or that there are circumstances where the visa may not have been granted had those circumstances existed at the time of application. That is not a narrow test. Global instability is not narrowing. If anything, more regions of the world are experiencing the kind of volatility that could trigger these conditions. Any country facing armed conflict, serious civil unrest, or sudden political collapse could theoretically put its citizens' Australian visa travel rights at risk overnight. Migration advisors have been telling their clients to check the Department of Home Affairs website before every international departure if they hold a temporary Australian visa and are from what they describe as a conflict-affected region. Passports from Lebanon, Iraq, and Syria have been specifically mentioned by advisors as warranting close monitoring. These are not announcements or confirmed targets. They are professional risk assessments based on the current global situation and the language of the legislation. And here is the mistake that thousands of people are already making right now, that could cost them enormously. They are assuming that because their visa was approved, their travel is confirmed. They are booking flights, paying for accommodation, making concrete plans, and not checking, or not checking frequently enough, whether an arrival control determination has been issued. The visa grant and the ability to travel are no longer the same thing. They were once. They are not anymore. A visa grant is now a conditional permission, and the condition can change without you receiving any personal notice. Let us talk about what happens to the actual visa when a determination is in force, because this confuses a lot of people and it matters enormously. Your visa is not canceled, it is suspended. That distinction has real practical consequences. If the determination expires and is not renewed, your visa comes back to life. It resumes for the original period it was issued for. You can then use it to travel to Australia. Your application fees are not refunded. The visa still exists, but the clock on its validity period essentially pauses while the determination is in force, at least in theory. In practice, if a tourist visa was issued with a validity period that expires while the determination is running, you may find yourself holding a technically suspended visa that expires before you can use it. This is one of the many wrinkles that migration lawyers are currently trying to work through with their clients. Now, there are exemptions. The determination is not absolute for every single Iranian national. The government has carved out some limited exceptions. If you are already inside Australia when the determination takes effect, you are not affected. You can continue to be in Australia for the duration of your visa. If you had already begun your journey to Australia before the determination came into force, meaning you were in transit in a third country for less than 24 hours, you would generally be allowed to continue. If you are the spouse, dependent child, or parent of an Australian citizen or permanent resident, there is provision for sympathetic consideration, and you may be able to apply for what is called a permitted travel certificate, which is a case-by-case exemption. Parents of Australian citizens have been specifically mentioned as a category where the government intends to be sympathetic. But, and this is a very big but, there is no automatic right to a permitted travel certificate. There is no formal hearing process. Natural justice does not apply to this decision. The bar for exemptions is extremely high, and advocacy groups have said the burden of proof required is onerous. You cannot simply tell the government you have a valid reason. You need to demonstrate it with documentation, and even then the minister is not compelled to grant the exemption. If you need to apply for a permitted travel certificate, you can do so through the Arrival Control Determination portal on the Department of Home Affairs website. The website address is homeaffairs.gov.au. Go there, look for the Arrival Control Determination section, and follow the instructions carefully. But please, seek professional immigration advice before doing anything. These are complex legal circumstances, and a small mistake in how you frame your exemption request could result in a denial. Now let me talk about the bigger picture here, because this is where things get really significant for anyone connected to Australia, not just Iranians. Australia has effectively built what migration experts are calling a digital border system. Because the determinations flow through the advanced passenger processing system, the ban is enforced at the point of check-in anywhere in the world. You do not even get to an Australian airport before you are turned away. You are stopped at the departure point. The airline does it. The government does not even need officers physically present. The system flags you automatically. The airline gets the message. You are not boarded. This is a fundamentally different kind of border control from anything Australia has had before. And Australia is not alone in this direction. Other major countries, including the United States, Canada, the United Kingdom, Japan, and Germany, have also been tightening entry restrictions for Iranian nationals during this period. But what makes Australia's approach uniquely powerful and uniquely alarming to civil libertarians is that it is not just a general policy of stricter scrutiny. It is a legislative mechanism that can override an already granted visa with no individual notice, no appeal, affecting thousands of people at once. Let me give you a scenario to make this real. Imagine you are an Iranian Australian. Your parents are elderly and they live in Tehran. The situation in Iran is dangerous. You are worried about them. You want them to come and stay with you in Sydney for a few months. You help them apply for a subclass 600 tourist visa. They go through the whole process. Months of waiting, medical checks, character checks, documents proving family ties. Finally, the visa comes through. You book the flights. Your mother and father are at the airport in Tehran, ready to board. And then, the night before their flight, the minister signs an arrival control determination. The airline flags their booking. They cannot board. They are stuck in Iran, in a conflict zone, with a valid Australian visa that they cannot use. And you are in Sydney, helpless, because there is no emergency phone line, no fast-track tribunal, no system designed to deal with this at speed. This is not a hypothetical designed to be dramatic. This is the reality of the legal framework that now exists. The government says it will be sympathetically considering parents of Australian citizens. But sympathy is not a legal right. Sympathy is discretion. And discretion, without a review mechanism, is another word for we will decide and you will have to accept it. So what should you actually do right now if any of this applies to you? If you are Iranian and you are currently in Australia on any temporary visa, tourist, student, work, graduate, you are not affected by the current determination. You can remain in Australia for the duration of your visa. But do not leave Australia right now if you are on a subclass 600 visitor visa. If you leave, you will not be able to return for the duration of the determination. Stay put and speak to a registered migration agent about your options. If you are Iranian and you are outside Australia and you hold a subclass 600 tourist visa, your travel rights are currently suspended until at least September 2026. The visa is not canceled. Keep your visa grant documentation. Monitor the Department of Home Affairs website for updates. If you have a genuine humanitarian or compelling reason to travel, family emergency, close relative who is an Australian citizen, apply for a permitted travel certificate through the Arrival Control Determination portal and do this with professional immigration legal advice. If you are Iranian and you hold a different type of Australian visa, a student visa, a work visa, a temporary graduate visa, you are not currently caught by this specific determination. The current determination only covers subclass 600 visitor visas. But do not be complacent. The minister has the power to expand the determination or issue a new one covering different visa classes. Stay alert. Check the Department of Home Affairs website regularly. If you are from any other country that is currently experiencing conflict or political instability, especially in the Middle East or nearby regions, and you hold an Australian temporary visa, this is the moment to be proactive. The current determination affects only Iranian subclass 600 holders, but the legal framework exists to expand this. Monitor the situation. Speak to a migration agent if you have any doubts. And above all, do not assume that a granted visa means guaranteed travel. If you are a student or academic who had Iranian colleagues or family members planning to visit Australia for conferences, short courses, or research programs, reach out to your institutions now. Australian universities are actively seeking guidance on refunds and deferrals. There may be options available through your institution's international office. If you are a business owner or employer with Iranian nationals who travel to Australia for work or who plan to visit, suspend any non-essential travel planning immediately until the situation becomes clearer. Explore remote work options. Consider the duty of care implications if staff are separated from family members who are now unable to travel. Document everything. Your travel risk assessments need to be updated right now to reflect this new reality. There is one more thing I want to say before we close, because it speaks to something much larger than this one determination. What happened on March 26, 2026, changed the fundamental nature of what it means to have an Australian visa. For decades, a visa grant was a promise. It was the Australian government saying, "We have assessed you. We have reviewed your documents. We have made a decision, and we are telling you that you are welcome to come." That promise is no longer unconditional. The government has created a mechanism that allows it to take back that promise. Not because of anything you did wrong, not because your circumstances changed, but because the geopolitical environment changed, and the minister decided that a group you belong to represents a migration risk. You as an individual did not matter. Your individual circumstances were not weighed. Your name was not on the determination. Your nationality and your visa subclass were. That is a seismic shift, and it deserves serious attention, not just from people directly affected by the Iran determination, but from anyone who believes that visa systems should be predictable, transparent, and fair. The immigration lawyers are watching. The crossbench is watching. Human rights organizations are watching. And they are all asking the same question. If this can be done to Iranian tourist visa holders this week, what stops it from being done to another nationality next week? The minister says the powers are necessary. The government says they are proportionate and time-limited. The critics say the precedent is dangerous and the safeguards are inadequate. What we know for certain is this. Section 84B is now law. It has been used. It will almost certainly be used again. And the world it creates is one where holding a valid visa to Australia does not mean what it used to mean. If you found this video helpful, please share it with anyone you know who is affected by these changes or who holds an Australian visa and travels internationally. This is the kind of information that does not always reach the people who need it most. Like this video so that more people can find it. Subscribe to this channel so you are the first to know when we cover the next update, because this story is far from over. The 6-month determination expires in September 2026, and by then the landscape could look very different. The minister could lift it, extend it, or expand it to other nationalities. We will be covering every development as it happens. Drop your questions in the comments below. Are you Iranian and affected by this? Are you worried about other countries being added? Are you a migration agent or lawyer who wants to add to this discussion? I read every comment, and your questions often shape the next video. Tell me what you want me to cover next. The visa landscape in Australia has changed. Make sure you are informed. Make sure your family is informed. And make sure you are not caught at an airport with a valid visa that cannot get you on the plane. Script for YouTube. All information based on publicly available official sources including the Department of Home Affairs website, homeaffairs.gov.au, and parliamentary records. Not legal advice. Consult a registered migration agent for individual circumstances. Share.